Looks like we have some new documents. Let's go ahead and get started. Hey guys, this is Jules with True Crime Reactions. We have 4 new filings in the Idaho 4 case that just became public. I'm now going to switch over to a new way that I'm going to be recording this while we are going over documents, so I'm about to get real tiny. So, like I mentioned, there's 4 new filings that we need to go through. I'm actually going to open the last one first because it is the state's response to the defendant's motion, which would have been the one up here on 6-9 of 23, the motion for an exception, or in the alternative to extend time. So we're going to go ahead and open that one now. Now, as it shows here, the state's response to defendant's motion for an exception are in the alternative to extend time for compliance with IC 19-519. And this one just states, come now, the state of Idaho, by and through the Latah County prosecuting attorney, and respectfully submits the following response to the defendant's motion for an exception or in the alternative to extend time for compliance. The state acknowledges that the discovery in this case is substantial and ongoing. The state also recognizes that this case is currently set for jury trial, projected to last 4 to 6 weeks and starting in less than 4 months. Balancing the above, the state has no objection to a reasonable extension of time for the defense to comply with its obligations under Idaho Code 19-519, with the understanding and expectation that the state will likewise have a reasonable period of time to respond to any proffered notice of alibi, and with the addition understanding that any defense compliance with Idaho Code 19-519 occur by July 24th of 2023. Okay, so we're going to go look up this right here. Okay, so it is the notice of defense alibi. Okay, I was pretty positive that's what that meant, but I just wanted to clarify. This is the defendant's reply to state's supplemental response to defendant's motions regarding the grand jury record and transcript. So this is literally the defense still waiting on the grand jury information. And I'm going to skip this first sentence of legal blah, blah, blah. The state argues that Mr. Koberger is only entitled to an audio recording and or transcript of the grand jury proceedings and the grand jury notes, but not the other enumerated items set forth in Idaho Criminal Rule 6. The state also objects to a qualified protective order, preferring instead to keep requested materials protected by adherence of the word sealed. Release of the grand jury proceedings governed by rule and statute are materials necessary to Mr. Koberger's defense. Yes, and yes, they are. Article 1, Section 8 of the Idaho Constitution, all these different things, blah, 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 provide authority for release to Mr. Koberger. So there are basically all these freaking codes in here that I'm not going to misspeak, all these numbers, are basically the rules and reasons that the defense is setting forth to be presented that proves that Mr. Koberger's team deserves and has the right to the grand jury proceedings. Okay? Good cause is not required, but exists to release all items in Mr. Koberger's motion as set below. Procedural background. Mr. Koberger was indicted by a grand jury on May 16th. He filed a motion to make available the record of all proceedings of the grand jury and a motion requesting release of grand jury materials under qualified protective order on May 19th. The state then filed their state's response to defendant's motion regarding grand jury record and transcript and proposed order on May 30th, 2023. The parties were not able to reach an agreement regarding the release of grand jury materials, which resulted in the state filing their state's supplemental response to defendant's motions regarding grand jury record and transcript on June the 6th. So 8 days ago? The defense reply follows. Argument. Mr. Koberger has a legal right to challenge the grand jury indictment, and the court should release all records requested in this motion. Mr. Koberger faces charges for 4 counts of first-degree murder and 1 count of burglary. Because of the first-degree murder charges, the state can file notice of intent to seek the death penalty. Mr. Koberger's early January court appearance, counsel for Mr. Koberger and the state planned for a preliminary hearing scheduled the week of June 26th. A preliminary hearing would have allowed the defense to challenge evidence the state claims to have against Mr. Koberger. The state, as is its option, chose to proceed with a secret grand jury. A grand jury was impaneled at a time when the small community of Moscow, Idaho had been exposed to 6 months of intense local, national, and international media coverage. Because the state has provided extensive discovery, Mr. Koberger knows that exculpatory evidence exists. Whether a fair and impartial panel of grand jurors was assembled amidst intense media coverage is a significant question the defense must evaluate. Whether inadmissible or exculpatory evidence was presented to the grand jury is a significant question the defense must evaluate. And while there are many other legal arguments Mr. Koberger may pursue related to the grand jury proceedings, how the grand jury was selected and what evidence was presented illustrate good cause for the defense's need for all materials set forth in its motion. Which I've actually really thought about that, because they've been telling us for a while that Bethany apparently has exculpatory evidence to show that Brian Koberger should be exonerated. Okay, so that must mean that there is something already in all of the files that the prosecution most likely already has in their possession that Brian Koberger and his team knows is exculpatory towards him, or at least that's what they're claiming in all of these records. So knowing that there's something in there that should exonerate him and be considered exculpatory, and he was still indicted by the grand jury, that leads the defense to believe that not fair and accurate information was presented, which, normally at a grand jury, because it's one-sided, that's how it always ends up going. Mr. Koberger is entitled to pursue relief on a single error or cumulative errors. To determine if there are cumulative errors, good cause exists to review all items requested in his motion. Cumulative error exists when the cumulative effect of the errors and discretions, none of which alone might have been enough to tip the scale, operate. Prejudice by producing a biased grand jury. There's a lot of weird abbreviations and all of this stuff. Noting under the doctrine of cumulative error, a series of errors, harmless in and of themselves, may in the aggregate show the absence of a fair trial. So even if one little thing is wrong, it could cause basically like a domino effect of everything else, which is basically another way of, I guess, kind of viewing the fruit of the poisonous tree, because once there's that one little thing that's incorrect, then a domino effects down the line. So I guess it's pretty much like what they're trying to say here, whether one error or one error that then in turn creates multiple errors. But regardless, you shouldn't have to put all this information in there just to be able to get the grand jury proceedings. It's really unfair that all of this is even having to go on. I don't understand how they expect him to be able to defend himself if he really has no idea what he's defending himself against, because if he's indicted and he's claiming that in the evidence is something exculpatory, then like I said, he must obviously, or they must obviously know something isn't being presented correctly. Pursuant to Idaho Criminal Rule 48 and all of these other codes, Mr. Koberger is entitled to request the proceedings be stayed while he challenges the indictment, which is also something that we knew was going to probably happen because, like we mentioned, there's been already talks of things being extended and pushed back, and this is just another one of those that seems pretty normal, honestly. The rules provide for the release of all enumerated items in Mr. Koberger's motion without good cause. Mr. Koberger is requesting items listed in Idaho Criminal Rule 6 and 19-1001, 2021, 1201, and 1401. Mr. Koberger is not seeking anything outside of rule or statute. Each portion of the grand jury proceedings is specified in his original motion and in the rule. The state's suggestions that he should listen to the audio recording recording and or review a transcript of incomplete proceedings merely adds delay to Mr. Koberger's ability to challenge the grand jury indictment, which is true. Essentially, Mr. Koberger is asked to look at some but not all, and then ask for more at a later time, which it is. It sounds like they're saying, go ahead and look at the transcripts and listen to the audio now, even though we've been telling you for a while now that it's not even ready for review. Yeah, that's like, get all this now and let us like get the rest of our ish together and then we'll send you the rest. That's not how that's supposed to work. Mr. Koberger's right of a speedy trial has not been waived. This sort of delay would require either a waiver of his important right to a speedy trial or for counsel to represent him less than fully prepared. Yeah. As such, Mr. Koberger, under separate but contemporaneous filing, is requesting that his case be stayed during the now contested process of obtaining materials he must examine. Authority for a stay is contained in this Idaho code. A party may move to stay the proceedings and in a criminal case to quash the indictment, which is another thing that we did see coming, and for other appropriate relief on the ground of substantial failure to comply with this chapter in selecting the grand or trial jury. Mr. Koberger is acting with diligence to discover grounds upon which to challenge the indictment through a motion to dismiss. Another very thing that we thought was going to happen. The state's obstruction of release of the full grand jury proceedings is creating unnecessary delay. This case should be stayed until Mr. Koberger has complete access to all matters related to the grand jury proceedings and until such time as he can fit an Idaho Rule 48 motion to dismiss the indictment, or as Mr. Koberger is requesting, the court should order all grand jury records released so that defense work can be done. The state's reliance on State versus Abdullah for the standard that good cause is required is not accurate. Mr. Abdullah's grand jury proceedings were in 2014 before the ICR 6.2, which was adopted in 2017. The rule does not require good cause, and even if it did, good cause exists as explained earlier. In Mr. Abdullah's post-conviction case, he was arguing that grand jury transcripts that had not been included in the appellate record needed to be added and briefed as a subsequent issue. Mr. Abdullah wanted to argue that the grand jury term had expired. In this case, Mr. Koberger is asking for grand jury records immediately following his indictment and before jury trial, not years later in a post-conviction proceeding. It is worth noting that Abdullah illustrates how issues such as this have plagued cases in the appellate realm for decades. Release of the grand jury records now allows Mr. Koberger's defense to provide effective representation. And honestly, in turn, also doesn't allow there to be any stance for anything that is decided come sentencing or conviction to then be overturned for inadequate representation, which we see a lot in these cases. Somebody can come out and file a bunch of stuff claiming that their previous attorney did not represent them correctly and give examples about what this person might have done incorrectly or not have presented that they knew about later that could have helped their defense, and then everything starts over again. So then basically they're covering their bases here for Brian in this exact situation, but then the defense is also protecting their own butts in the long run doing all this too. Sealed versus qualified protective order. Mr. Koberger seeks access to these records whether sealed or under a qualified protective order. Defense counsel needs to be able to disclose the grand jury records to the defense team, including relevant experts, with the admonition that the records are not to be copied or dispersed. Defense counsel needs to be able to review the records with Mr. Koberger, but does not seek an order to provide him with a copy. Additionally, the defense needs to be able to refer to the records in legal challenges or witness examination. Yeah, they need to know what they need to reference. To protect the sensitive nature of the records and pleadings referencing grand jury proceedings, any such pleadings can be submitted to the court with a motion to seal. Conclusion. Mr. Koberger is entitled to review all grand jury proceedings as set forth in his original motion to make available the record of all proceedings of the grand jury pursuant to ICR 6.2 filed on May 19th of 2023. Although good cause is not required, it exists because a grand jury was impaneled after 6 months of intense media coverage in a small community. Exculpatory evidence exists. They are adamant about that, guys. And there may be a single error or cumulative errors which require the examination of the entire grand jury record. I mean, regardless, y'all should be able to look at the whole thing anyway. He does not object to the recordings being sealed as clarified earlier. He agrees with the state that grand juror notes should be included in the records provided. Should the court release only partial records or transcripts, Mr. Koberger requests a stay of all proceedings pursuant to Idaho Code 2-213 until such time as he is able to review, request additional records, provide a sworn statement of reasons, and file an ICR 48 motion to dismiss, which again is correct too, because again, for their own sakes and to cover their own butts in the future and now, they need to be able to file a motion to dismiss. They have to. It's basically a step that they have no choice but to take here. And in order for them to file an adequate one, that is an actual fight against this indictment, they have to have all of the information that was presented at the grand jury. They cannot sit there and fight blindly. They have to have all of the information, which I don't understand why this is even such a problem, because duh, the state knows this. I don't understand, but okay. Now, this is the official motion to stay the proceedings. It's pretty much the exact same thing until we get to right here. This is interesting because it gives us the answer that we've really all been wondering when it came to the standing silent thing. And I know some people have talked about it, but this answer is coming directly from the defense. Mr. Koberger stood silent at his initial arraignment to preserve his right to contest the indictment. So right there you have it. It was definitely a tactic that they used on purpose. It wasn't no last minute thing, because Brian Koberger had no issue at all answering the judge when it came to him understanding certain things and what was actually going on prior to the guilty or not guilty question. As soon as it got to that point, Ann Taylor immediately stood up. It was literally on cue. So anyone who thought that this wasn't already a pre-planned tactic, y'all are out of y'all's mind, because that was the most orchestrated thing I've ever seen in my life. Now, the ending of this is state's argument. By the time this court hears argument on the preparation of the grand jury proceedings, almost 6 weeks will have passed from the time of indictment. Preparation of the grand jury record will take additional time. Mr. Koberger has the right and intends to contest the indictment. And then it states that the Idaho Code allows the defense to seek a stay of proceedings within 7 days after the moving party discovers or by the exercise of diligence could have discovered the grounds therefore, and in any event before the trial jury is sworn to try the case, a party may move to stay the proceedings and in a criminal case to quash the indictment and for other appropriate relief on the ground of substantial failure to comply with this chapter in selecting the grand or trial jury. Koberger seeks to stay the proceedings as appropriate relief while the matter of the grand jury record is argued and prepared. He is exercising due diligence to discover the grounds upon which to file a motion to dismiss related to how the grand jury was selected. He is being delayed through no fault of his own. Conclusion. Mr. Koberger's request to stay proceedings until the grand jury record is prepared and he has adequate time to contest the indictment should be granted. The remedies allowed in Idaho Code 2-2133 are the exclusive means by which a person accused of a crime may challenge a grand jury on the ground that the jury was not selected in conformity with this chapter. A stay of proceedings is appropriate. And that's it for this one, and we do not actually have a response on this yet. Now, this last one, the fourth one, is the notice of hearing when it comes to the motion for an exception or in the alternative to extend time for compliance with IC 19-519. Now, this is a hearing for oral arguments on June 27th, 23 at 1:30 p.m. But I don't know why we see this whenever the state just agreed to the extension. So I don't really know what that's about or if that's going to still be a thing now that we have the response being that they agree with it. I don't know. But that is it. That is all. Those are the documents that they posted today. Like I mentioned, while we were going through them, things being pushed back, times being extended, things like that was pretty much expected in this case. Most people just rolled their eyes whenever they heard an October of 2023 trial date because we all knew better. But yeah, those are the documents. See y'all.